Today, we saw the first televised standoff in the case brought by Fulton County District Attorney Fani Willis against the disgraced ex-president Donald Trump and 18 other co-defendants in that plot to overturn Joe Biden's 2020 victory in the state of Georgia. It was our first glimpse at the game of chicken some of the defendants are trying to play. Notably, Willis's team did not blink. That first glimpse inside the courtroom also showed just how complicated it is to prosecute an attempted coup and each individual member of that conspiracy. The hearing was nominally about whether or not former Trump lawyers Kenneth Chesebro and Sidney Powell can sever or separate their cases from the other 17 co-defendants. But prosecutors for Fani Willis's team argued that the government is ready to make its case against all 19 co-defendants together this October. Watch.
We will contend that a trial of these 19 co-defendants will take 4 months, and that does not include jury selection. There are in excess of 150 witnesses that the state intends to call. Judge, we contend that we must prove the entire conspiracy against each and every one charged. Each and every one charged. So the court, in the interest of judicial economy, would have to make the decision as to whether or not the court wants to try the same case 19 times.
So in addition to hearing from Fani Willis's team, as you did right there, this was also the first time that we've heard from the judge in the case, Scott McAfee, who seems skeptical that a trial of this magnitude could be dealt with in a few months.
It just seems a bit unrealistic to think that we can handle all 19 in 40-something days. That's my initial reaction, thinking of just how to get this. And are we even delaying the inevitable? If we say there's no severance, aren't we going to have 17 defense attorneys get up here and file motions for a continuance just saying they're not ready?
Now, ultimately, Judge McAfee ruled that Chesebro and Powell will be tried together, that they could not sever from one another on October 23rd. Whether or not there are 17 co-defendants, and that, of course, includes Donald Trump, will be tried alongside them on that day, is still up in the air. It's where we start today with some of our favorite friends. Let's bring in MSNBC legal analyst and MSNBC host Katie Phang. She was in the courtroom for today's hearing, and she joins us from the Fulton County Courthouse. Also joining us, former U.S. Attorney and current MSNBC legal analyst Barbara McQuaid, and former Assistant Director for Counterintelligence at the FBI, MSNBC National Security Analyst Frank Figliuzzi is back with us. Katie Phang, I am not a lawyer. This is appearing to be a real hurdle in doing my job these days. But can you give me a non-legal explanation of why we care about severance and what outcome we should be rooting for if we are on the side of accountability and the rule of law?
Well, to answer your question, if you care about justice and you care about accountability, you want it to be swift. You want it to be competently done, and you want it to be done in fairness and with due process considerations. But you certainly don't want to see justice in the form of a jury verdict in Fulton County, Georgia, maybe 4 or 5 years down the road. I mean, there is that saying, right, Nicole? The wheels of justice may grind slowly, but they do grind. And I think in this particular instance, you saw for the very first time a substantive appearance from the presiding judge, Scott McAfee. Those of us in court, and also the wondrous event of having it broadcast and, live streamed for everyone to take a part of, you were able to see Scott McAfee handle not only the state and its arguments, but the defense and their arguments. You also saw the beginning of what could potentially be a division in the defendants. Kenneth Chesebro's lawyers trying to play nice in the sandbox with Sidney Powell's lawyer, but making it clear that they had no connection with each other, let alone with the other defendants in this case. But what's critically important is the idea that the judge swiftly ruled from the bench. Those of us as trial lawyers always want to get a quick ruling from a judge when we're in court on a hearing that is this important. But there are logistical, practical nightmares that cannot be ignored when it comes to the idea of trying 19 defendants together. I'll set the table for you a little bit here and for our viewers. The state could accommodate at its table only 4 lawyers. There were 4 lawyers that were sitting on behalf of the state of Georgia in the very first row of the peanut gallery where the rest of the public was sitting. There were only 3 lawyers sitting at counsel's table for the defense. 2 for Kenneth Chesebro, 1 for Sidney Powell. Can you envision then the idea of a minimum of 1, 2, maybe more lawyers on behalf of 19 defendants sitting in that courtroom? It's not just the geography. It's not just the real estate. It's the idea of everything that leads up to that trial, Nicole. It's the pretrial motions. It's the idea also that there's a pending ruling from a federal judge as to whether or not removal occurs. And that was a major question that was posed by Judge McAfee. It's the first time anybody has raised it yet from either the bench or from the kind of gaggle of lawyers that we speak to when we're here. It's the idea of double jeopardy attaching. When you swear in a jury, you end up having jeopardy attached to a case. So it's the idea that you can't try a defendant again once that jury's been sworn in. Judge McAfee asking the state specifically, almost be careful what you wish for if you want all 19 at the same time. What if I pick a jury and I swear them in and there's pending removal or there's removal of defendants to federal court that end up coming back to state court eventually once appellate remedies are completely exhausted? And so really it was a, how do I manage this? How do I literally manage 19 defendants today? And we're going to be seeing some additional briefing by next Tuesday, which is the deadline for the state to tell the court, answering questions about removal, answering questions about, do you really do 19 defendants at one time? And then a separate trial for just Kenneth Chesebro and Sidney Powell.
Barbara, let me show you some of what this looked like in court. This is another member of Fani Willis's team making the argument about the evidence applying to all 19 of the defendants.
So we've heard a lot from both defendants about they didn't know the other people. They were located thousands of miles apart. They didn't even know that the other parts of the conspiracy were going on. But the case law is clear that that does not matter. Of course, anytime a person enters into a conspiracy, they are liable for all of the acts of all of their co-conspirators. And that's it. Evidence against one is evidence against all.
This seems obvious, again, to me, the non-lawyer here, that just because they were working on different parts of the coup, they were all trying to illegally overturn Trump's defeat. Some were working in Georgia, some were working in the Justice Department. They were all doing the same thing. Was that an effective presentation, in your opinion, from Fani Willis's team, Barb?
Yes. In fact, you've heard this defense from a number of people. I think Rudy Giuliani is one who said, I don't even know some of these people I'm indicted with. How could I possibly have committed a crime with them? But what we just heard from the prosecutor there is the law. And that is you can be charged in a conspiracy even if you don't know everyone else who is in the conspiracy. The question is, did you agree with others to commit this illegal act? That is also why RICO is such a powerful tool for prosecutors, because it brings in separate schemes all together under the same umbrella if they were united in a common scheme, which is what is alleged here. So the mere fact that Kenneth Chesebro may not know Sidney Powell and they may not have been working on the same piece of this case, it doesn't matter legally whether they are in the same trial or not. And so I don't think the argument that they should be severed from each other is going to matter much to the judge.